Does the owner of a landlocked property have legal rights to access a public right-of-way? So, for example, a person owns a 10-acre tract of land which is completely surrounded by a bigger tract of land. Now, currently, the person who owns the landlocked property accesses it from a public road using a dirt road through the larger tract of land with the owner's permission, but there's no legal right-of-way set up. So if the owner of the landlocked property ever wants to sell it, any buyer is likely to want to have assurances that they have legal access to it. So the question is, does North Carolina law give the owner of a landlocked property legal rights to access their property? Now, if you run into this circumstance, what you really should do is contact an attorney, because this is always a complicated situation. But I believe in most circumstances, the owner of the landlocked property does not necessarily have rights to a public right-of-way simply because it's landlocked under North Carolina law. Now, there is something called, there's statutory procedure for establishing a cartway, possibly, but that is only if the land is used for things like, cultivating and removing timber, working of any quarries, mines, or minerals, operating a manufacturing plant, or a public or private cemetery, that sort of thing. There may be legal basis for claiming what is known under common law as an implied easement by necessity, but the law of implied easements is, again, quite complicated, so you're going to want to talk to an attorney about that. The best course of action is probably just to request a formal easement for legal access to a public right-of-way from the owner of the larger tract of land. Hope this helps. Thanks.